The United States Department of Justice has issued a strong rebuke against a judge who has halted the enforcement of a White House executive order aimed at penalizing a notable law firm. This move continues a pattern of the Trump administration's criticism of the judiciary over decisions that do not align with their interests. Attorney General Pam Bondi has informed federal agencies that they still possess the authority to decide with whom to work, despite a court ruling last month that temporarily blocked the administration's efforts to prevent Jenner and Block employees from accessing federal buildings. The ruling also instructed that federal contracts held by the firm or its clients be reviewed and possibly terminated. Jenner and Block is one of several prominent law firms recently targeted by similarly worded executive orders from the Republican president. Some, like Jenner and Block, have taken legal action against these orders, while others have reached settlements to avoid sanctions from the White House. U.S. District Judge John Bates, appointed by President George W. Bush, stopped key provisions of the executive order from taking effect last month, and is considering a request by the firm to block its enforcement permanently. In a public letter released late Tuesday, Bondi and White House Budget Director Russell Vought informed agency heads about the judge's ruling, while also criticizing him for it. They wrote, on March 28, 2025, an unelected district court yet again invaded the policymaking and free speech prerogatives of the executive branch, including by requiring the Attorney General and the OMB Director to pen a letter to the head of every executive department and agency. They further stated, local district judges lack this authority, and the Supreme Court should swiftly constrain these judges' blatant overstepping of the judicial power. The letter was filed in federal court in Washington as part of a report on the status of the lawsuit brought by Jenner and Block. It adds, of course, as noted in the court order, agencies are permitted to carry on their ordinary course of business, which carries with it the authority to decide with whom to work. Additionally, it states, as it remains the executive branch's position that Executive Order 14,246 was necessary policy, the government reserves the right to take all necessary and legal actions regarding lawfare, national security concerns, and discriminatory practices involving Jenner and Block. This stance could potentially place the administration in conflict with Judge Bates' order, which directed the Trump administration to inform federal agencies to disregard broad swaths of its executive order. However, a separate provision of the order, mandating the suspension of active security clearances for employees at the firm, remains unaffected by the judge's ruling. Jenner and Block, along with WilmerHale, another firm targeted by an executive order, requested federal judges on Tuesday to permanently block enforcement of the orders against them. The executive order against Jenner and Block partly stem from the firm's previous employment of Andrew Weissman, a lawyer who served on special counsel Robert Mueller's team investigating Trump during his first term over potential connections between his 2016 campaign and Russia. Weissman, often criticized publicly by Trump, left the firm several years ago. Although Mueller has retired from WilmerHale, a White House executive order targeting that firm mentioned him, as well as another retired partner and a current partner who all served on Mueller's team. Besides Jenner and Block and WilmerHale, other firms targeted by executive orders include Perkins Coie and Covington and Burling. Last month, after facing a similar order, Paul Weiss struck a deal with the White House that resulted in the order being rescinded. 3 other firms, Skadden, Arps, Slate, Meagher and Flom, Milbank and Wilkie, Farr and Gallagher, have reached settlements with the Trump administration before they could be subject to an order.